So Clark, the decision in the Akzo Nobel case, what do in-house lawyers really need to know?
Well, I think a couple of key things come out of it. First is this is the third challenge on this topic, third level of appeal, lost again, and this is probably an end to it now. We have a final decision, we are at the end point. Secondly, of course, that end point is that the advice that in-house lawyers give to their employers, to their client employer, in relation to competition aspects that then turn into an EU Commission-led competition inquiry, that advice is not privileged. That's different to if they were using an external lawyer. The external lawyer's advice would have privilege, the in-house lawyer does not. And of course that was the basis of the challenge because it was unfair. The reason that the court has come to that decision each time has been around this question of independence, and every time the court has been saying that for EU purposes the in-house lawyer is not sufficiently independent of the employer, and that's even notwithstanding if that in-house lawyer is also a member of an independent bar or a law society and so regulated by professional conduct rules from that professional body. It's not enough, they've said. It's probably worth bearing in mind that in the Akzo Nobel case there was a real concern that the piece of advice which was the subject of all of the scrutiny was actually feeding into the policy, which of course the competition investigation was challenging, and the court viewed that as, you know, always likely to veer away from sufficient independence, whether in fact it did or did not.
What can an in-house lawyer do to mitigate risk?
There are some things. I mean, it looks like a challenging decision because privilege does not attach. That's the headline. But actually, there is lots of bits and flows underneath that. So first off, bit trite, but you know, and won't be necessarily popular in the in-house community, but you can always go out and instruct an external lawyer, you know, and they will always be delighted to help. Obviously, of course, there's a cost element to that, makes it unattractive, and it's why you've got the in-house team in the first place to try and avoid that. But it is a solution. If you're worried about it, you can do that. It gives you a sort of insurance policy. There is the issue about when you have internal advice coming, whether you should be going on to paper or whether you should try and use conversations more so that you don't have records that the commission can then come and look at. Obviously there's a real business aspect on that. Sometimes you do need some written advice so that everybody knows what the position is. Thirdly, of course, you should still mark everything privileged and confidential that's being generated out of the in-house legal team. There's a couple of reasons for that. One is it's always worth having a go, you know, so you know, err on the side of being as wide as you possibly can be and as protected as you can be. And secondly, this Akzo Nobel case, it's just about commission-led investigations. So if it's an OFT-led investigation in the UK, Akzo Nobel doesn't apply, and in the UK, the advice given by in-house lawyers is privileged. So mark it as privileged, because if it's an OFT-led investigation, it will be privileged, and actually in any other kind of, you know, court dispute, it will be privileged. A legal advice privilege will attach. So mark it anyway. It's also worth reminding ourselves that in Akzo Nobel, the court was very clear that if the commission do come and knock on the door, they are not allowed to look at the documents that you say are privileged if you challenge their right to inspect. They did in Akzo Nobel, they were told off that was wrong. They're not allowed to look. It goes straight into an envelope and it goes to the court for that aspect to be decided. Okay, so bear that in mind as well. If they do come knocking, they're not allowed to look. The final thing that you can look at, and this is perhaps a bit towards perfection rather than realistic, but it is something to look at, is running a sort of document list internally, so that if somebody comes in and challenges, you can go through the list and work out whether, you know, you think something is privileged or not, so that nobody needs to go and look at the source document. You know, you can decide off the list. Now, that's perfection, of course, because actually in reality running that kind of list and know-how database is very challenging indeed, but that's perfection if you wanted it.
Can you give me a quick update on all of the issues relating to reasonable endeavours?
Well, yes, there's been a recent case on that actually, quite an interesting case. It's called Jet2 and Blackpool Airport, and it's about a low-cost flyer, Jet2, who contracted to fly in and out of Blackpool Airport about 5 years ago. And one of the contractual clauses was that Blackpool would use all reasonable endeavours to assist Jet2 in running a low-cost airline. And if you can imagine, you're a low-cost airline, you need to keep your costs low, so that means that you fly in and out of airports as many times in a day as you can, and that means you need to start early and finish late. One, to get in the maximum number of flights, and two, because it's cheaper to land at 6 o'clock in the morning than at midday. The two parties had run the contract on that basis for 4 years, but Blackpool Airport was then taken over by a new shareholder, and on a review wanted to increase its own profitability. So what it decided to do was it should narrow the time slots that it offered to Jet2, because that would reduce its own cost base, and it would make more profit, and it did that on 7 days' notice, and of course that created a problem for Jet2, and they objected to it. It ended up in court on an expedited hearing, arguing over whether what Blackpool had done was or was not within the confines of this all reasonable endeavours obligation that it had taken on. And there was a question about what that meant for Blackpool Airport. What did the all reasonable endeavours entitle it to do? And historically, there's been a view that that clause does not mean that a party should act against its own financial interests. This case puts a separation between sort of doing something new that is an additional cost to you, which Blackpool wouldn't have had to do, as opposed to having run a contract a certain way for 4 years, allowing this concession, and then changing your mind because it suits you financially to close that down, because you'll then make more money and more profit. And Blackpool Airport, had an issue about its profitability and wanted to up its profitability. So that's why it did what it did. But the court said that was too much. That was a breach of the obligation. The interesting sting in the tail is that the court also said, well, all reasonable endeavours is not an absolute obligation. So it's not an absolute obligation on Blackpool over the next 10 years to honour necessarily these extended hours that they had been running to for 4 years. And over the next 10 years, the parties will have to agree effectively what all reasonable endeavours means. What did they have in mind by that? And if they can't agree, they'll end up back in court for a final determination. But on the expedited hearing that the court took for this decision, it said, I'm not prepared to impose what the answer to that is. The parties can go away and come back again for further direction if they need it, brackets at their future cost and expense. And the lesson to be learnt from that, of course, is what the courts are trying to force you to do, or the suggestion in the case is, please be as specific as you can in your contract, rather than using these loose sort of endeavours obligations when you could have provided certainty.
What about entire agreement clauses?
Again, a recent case, AXA Sun Life and Campbell Martin, looked at a couple of streams around entire agreement clauses, just taking two. The first one was around the old chestnut about, is a misrepresentation excluded by putting in an entire agreement clause? And the court was very clear once again in saying, look, if you want an entire agreement clause to exclude a misrepresentation, you have to say so very, very clearly indeed. If you just put the word representation into your entire agreement clause, no inclusion of prior warranties, representation, promises, then the court will view that as basically a contractual representation, i.e. a collateral warranty. You will exclude that there can be a collateral warranty attached to the side of your contract. You will not exclude a misrepresentation giving rise to a claim in tort, not in contract, that you entered into the contract because somebody told you something which you then relied on to your detriment in contracting with them. That won't work, the court said. You be very, very clear indeed if you want to exclude a misrepresentation. And you're back to some of those very complicated recent cases coming out of the sort of finance sector about how to exclude a misrepresentation, which is one, say so clearly, or two, say there haven't been any representations on which either party have say there haven't been any representations, or say that if there have been representations, neither party has relied on them. So you almost need a part two of your entire agreement clause to deal with that aspect. And the second stream was just around, quite interestingly, whether the unfair contract terms could apply to an entire agreement clause. And the court said, yes, it could in theory, because actually you're limiting your performance to that in the expectations around the contract, rather than what somebody might expect you to be doing because of things you said beforehand. So the court said, in theory, UCTA therefore does apply. Technically, you're within the bounds of UCTA and the clause could be struck down if not reasonable. in theory. In practice, it went on to say actually that that'll almost never happen. It'll always be reasonable. Always expect an entire agreement clause to be reasonable. Why is that? Well, one, the parties would expect their contract to be all-encompassing and not to have to go and find bits of their contract or their deal outside the contract. That's sort of what you have a contract for, to put it all in one place. That's what you'd expect, perfectly reasonable. Two, they add certainty, and the parties should like certainty. And the court also said, we like certainty, because certainty means you don't come and argue things in front of us, taking up our very valuable judicial time on your spats. Thirdly, these clauses appear in nearly all contracts now, certainly in all commercial contracts. So completely reasonable, you know, to be expected, get on with it.
Thank you, Clark.